Imagine a judge looking you dead in the eye and saying, we have enough evidence to prosecute you for this crime, but we've decided we aren't going to.
Which, sounds great at first.
Right. You might feel this massive wave of relief, right? You'd think you're totally off the hook.
But you're really, really not.
Exactly. Because then the judge says, however, you are not innocent. We aren't clearing your name. This charge is just going to hover over you indefinitely. Oh, and by the way, we might still use it to seize your money years from now.
Yeah, it's a scenario that sounds completely absurd.
Yeah.
It's like a glitch in the matrix of the justice system, but it actually happens.
It totally does. And welcome to today's deep dive, where we are exploring this bizarre, highly consequential legal limbo. It's hidden right inside the criminal law of England and Wales.
It's this administrative maneuver called letting a charge lie on file. Or sometimes they just say a charge on file.
And let me tell you, it is going to challenge every single assumption you have about how justice is actually supposed to work.
Oh, absolutely. Because, we are all raised on this very binary concept of the law, right?
Right, the whole guilty or not guilty thing.
Exactly. You go to court, a jury hears the evidence, and you're either guilty or you're not. But a charge lying on file, it completely shatters that binary.
So to help us navigate this whole mess, we are pulling from a really fascinating stack of legal materials today.
We've got the foundational definitions from Wikipedia and the law pages, which kind of map out the strict procedural rules of how this practice actually works.
Yeah, and we're also digging deep into some critical analysis by the legal commentator David Winch. Specifically, his work Accounting Evidence, which really tears into the financial and, well, the ethical consequences of this whole legal shortcut.
And shortcut is probably the most accurate word you could use for it. Though, as we'll see, shortcuts in the legal system often come with some pretty heavy hidden tolls.
Okay, so let's unpack the actual mechanics of this first. Because before we get to the outrage and the financial stuff, we really need to understand what this looks like physically in a courtroom.
Right, like how does a charge end up just, sitting in a drawer somewhere?
Exactly. Walk us through it.
Well, for a charge to officially lie on file, two very specific, very distinct hurdles have to be cleared by the presiding judge.
Okay, what's the first one?
The first hurdle is all about the actual weight of the accusation. So the judge has to look at the prosecution's case and officially agree that there is enough evidence for a case to be made.
So just to be clear for everyone listening, the judge is acting as a filter here.
Yeah, exactly.
They're looking at the police reports, the witness statements, the forensics, and saying, yes, the prosecution actually has the receipts. Like, if we put this in front of a jury, it's a completely viable case.
Right. And that's important because it prevents prosecutors from just putting completely baseless, frivolous charges on file just to intimidate someone.
Oh, that makes sense. So they can't just make stuff up.
Exactly. The evidentiary threshold has to be met, and the judge actually has to acknowledge it on the record. But it's the second hurdle where things get a bit messy.
Right, because if they have the evidence, my immediate thought is run the trial. That is literally what the system is built for.
You would assume so, yeah.
Huh.
But the second hurdle requires the judge to decide that it is not in the public interest for the prosecution to actually proceed with that trial.
Okay, and this is where I need to stop you. Because that phrase, not in the public interest, it sounds so incredibly noble.
It does, yeah.
It sounds like they are, protecting society from something. But when you dig into the legal texts, what does public interest actually mean in this specific context?
Well, in the vast majority of these cases, public interest is basically just polite legal phrasing for triage and budget management.
Wow, really?
Yeah. The sources show that a charge usually lies on file because the defendant has already admitted to or been convicted of other charges. And crucially, those other charges are almost always much more serious.
Okay, I want to make sure we lock this concept in for you listening, so let's build a scenario.
Okay, let's hear it.
Let's say a guy is arrested for a massive multi-million-pound bank heist. He was literally caught red-handed inside the vault.
Got it.
But on the way to the bank, he also stole a bicycle just to get down the street faster.
A very pragmatic criminal, I guess.
Right. So he's facing, say, 20 years in prison for the armed bank robbery. And the prosecution also has him on camera stealing the bicycle.
So they have the evidence. That clears the first hurdle.
Exactly. But the judge looks at the docket and says, look, we are already sending this guy away for 2 decades for the bank heist. Are we really going to spend another 3 days of court time, impanel a whole new jury, and spend thousands of pounds of taxpayer money to officially convict him of stealing a 200-pound bicycle?
And the answer from the court is, predictably, no.
Right.
I mean, the practical utility of securing that minor conviction is zero. The system has already achieved the necessary level of punishment and public protection with the bank robbery conviction.
So the bicycle theft charge is just allowed to lie on file.
Exactly. They basically just take the file and put it in a drawer.
But here is the massive caveat that makes this entire practice so bizarre to me. What is the defendant's actual official status regarding that bicycle theft?
Yeah, this is the part that really breaks people's brains. The defendant makes absolutely no admission to the charge lying on file. They do not plead guilty.
And the court doesn't declare them guilty either.
I know. There is absolutely no verdict recorded against them.
That is wild.
You're just completely suspended in this gray area. You aren't officially guilty, but because the trial was bypassed, you were never given the opportunity to prove yourself innocent either.
You just exist in this state of perpetual legal purgatory.
That's a great way to put it, yeah.
So if the state is bypassing the trial just to save time and money, I have to assume this isn't just a permanent get-out-of-jail-free card. Like, if they put the file in a drawer, there must be a way to open that drawer again later, right?
A drawer can absolutely be open. A charge lying on file is not dismissed. It's not erased.
Okay.
It remains active just in a dormant state. And it can be reinstated and brought to trial at a later date.
I mean, put yourself in that position for a second. The psychological weight of that is staggering.
It really is.
You have a judge who has gone on the official record saying, there is enough evidence to convict you of this. And instead of letting you fight it and clear your name, they just suspend it over your head indefinitely.
It's an incredible amount of leverage for the state to hold over a citizen, which is exactly why there are strict procedural safeguards in place. It's not just a free-for-all.
So a random prosecutor who happens to be having a bad day can't just, like, walk into the archives, pull your file out of the drawer, and drag you back to court because they feel like it.
No, they cannot. The procedural hurdle here is actually quite high. To reinstate a charge that has been lying on file, the prosecution must get the explicit official permission of either the original trial judge or the Court of Appeal.
Okay, so they have to go back to the judiciary and essentially ask for the keys to the drawer.
Exactly. They have to prove that circumstances have changed so dramatically that it is now suddenly in the public interest to spend the money and time to prosecute this old charge.
Okay, that's a pretty fundamental check and balance.
It is. It keeps the ultimate power to revive the case entirely in the hands of the judges, not the police or the prosecutors. So it prevents the state from using these dormant charges as a constant arbitrary threat to harass people.
I mean, that does make me feel slightly better. There is a heavy institutional lock on that door.
Yeah, definitely.
But as we transition to the second half of our deep dive here, we are about to discover that while the criminal trial might be locked behind a heavy door, there is a back door.
Oh, very lucrative back door.
Yes. And it is a back door that the state can use to walk right into your bank account.
We're basically moving from the theoretical philosophy of the law into the very tangible, very aggressive world of asset confiscation.
And this is where we really have to introduce a massive piece of legislation. It's called the Proceeds of Crime Act 2002.
All right.
Because when you read the documentation, it explicitly states that charges laid on file have, on occasion, been taken into account in actions under this act to confiscate the gains of criminal activity.
And this is the exact mechanism that legal scholars and civil liberties advocates absolutely tear their hair out over.
I am right there with them.
Right.
Because let's just trace the logic we just built. We established unequivocally that there is no admission of guilt for a charge on file.
Right.
There is no jury. There is no verdict. The defendant is not legally guilty of the crime. So how on earth is the state legally allowed to seize their money or their property for a crime they haven't been convicted of?
To understand how the state pulls this off, we have to look at how different branches of the legal system measure the truth. And it all comes down to the burden of proof.
Okay, break that down for us. What's the difference in the burden of proof here?
Well, in a criminal trial, where your liberty is at stake, where you might actually go to prison, the burden of proof is incredibly high.
Right.
The prosecution has to prove you committed the crime beyond a reasonable doubt. Let's call that like 99% certainty. If the jury has a reasonable doubt, you go free.
Right. That is the main firewall of the justice system. It's designed to be hard to breach.
Exactly. But the Proceeds of Crime Act often operates in the realm of civil recovery. They aren't trying to put you in prison. They're just trying to take your stuff.
Okay.
And in civil proceedings, the burden of proof is much, much lower. It's based on the balance of probabilities.
Meaning they just have to prove it's 51% likely that you did it. It is just more likely than not.
Precisely. Now, think of a charge lying on file like a dormant computer virus. The criminal trial, with its beyond a reasonable doubt standard, is the main firewall.
Okay, I follow you.
The prosecution didn't want to spend the time and money trying to hack through that main firewall for a lesser charge. So they put the charge on file.
They just left the virus dormant on the hard drive.
Exactly. But remember, the first hurdle the judge had to clear to put it on file in the first place.
Right, the judge had to officially declare that there was enough evidence for a case to be made.
Yes. And that judicial declaration acts as the backdoor. Years later, the state can initiate a civil recovery action under the Proceeds of Crime Act to take your assets. And to meet that lower 51% balance of probability standard, they simply point to the judge's original note.
Oh, wow. That is wow.
Yeah.
They say to the civil court, look, we didn't officially convict him of stealing the bicycle because we were busy with the bank heist, but a criminal judge already looked at the evidence and said it was strong enough to go to trial. Therefore, it is more than 51% likely he stole the bicycle. So we are taking the bicycle.
Or, more accurately, taking the money in your bank account that they claim came from selling the bicycle.
That's insane.
They bypass the criminal jury trial entirely, but they still reap the financial rewards of a conviction.
Which brings us directly to the core conflict of this deep dive and the incredibly sharp critique leveled by legal commentator David Winch in his work Accounting Evidence.
Right. Winch's argument is laser-focused on the ethical black hole that this practice creates.
He argues that using charges laid on file to confiscate gains under the Proceeds of Crime Act is a direct, undeniable breach of the presumption of innocence.
And if you grew up in any Western democracy, the presumption of innocence isn't just a rule. It is the absolute bedrock of the entire system.
Innocent until proven guilty. Not innocent until a judge says there's probably enough evidence, but we don't feel like proving it.
Exactly. Winch is pointing out that when the state confiscates your property based on a charge with no verdict, they're effectively treating you as a guilty person. They're enacting a punishment based entirely on an accusation and a preliminary assessment of evidence.
They're completely stripping you of your right to defend yourself. You don't get to cross-examine the witnesses. Your defense attorney doesn't get to poke holes in the forensics.
No, none of that.
You are just financially penalized by administrative decree.
It is a really devastating critique. But, to really understand why this practice survives, we have to look at the collision between Winch's civil liberties perspective and the harsh realities of the state. We have to look at the friction between innocence and efficiency.
Let me play devil's advocate for the state here for a second.
Sure, go for it.
Because if I put on my prosecutor's hat, I can understand why they fight to keep this mechanism alive. Let's go back to our bank robber. But let's say it wasn't a bicycle he stole. Let's say he was running a massive multi-million-pound money laundering syndicate.
Okay, a slight escalation from a bicycle.
Just a bit, yeah. So the police finally catch him, but they actually catch him on massive tax fraud. The tax fraud case is incredibly strong. It's a slam dunk that will put him away for 20 years.
Right.
Now, the money laundering case is also strong. The judge agrees there is enough evidence, but it would take 6 months in court and millions of pounds to litigate. So they just put the money laundering charge on file.
A classic application of judicial efficiency.
Right.
Makes sense.
Right. But here's the state's problem. The guy has 5 million pounds sitting in an offshore account that they absolutely know came from the money laundering.
Okay, I see where you're going with this.
If the state cannot use the Proceeds of Crime Act to seize that money based on the charge on file, what happens? The guy sits in jail for his tax fraud, serves his time, and then walks out 20 years later to a 5 million pound retirement fund built entirely on illicit money.
And from the state's perspective, and arguably the public's perspective too, that is a massive systemic failure.
Exactly.
The state's imperative is to ensure that crime literally does not pay. They view the Proceeds of Crime Act as a vital, necessary weapon to dismantle the financial infrastructure of criminality.
Right.
If they couldn't leverage charges on file, organized criminals might retain their illicit wealth purely because of court scheduling conflicts and the sheer cost of running a trial.
The state is essentially saying, look, Just because we were too busy prosecuting your other crimes to give you a trial for this one, that doesn't give you a free pass to keep the dirty money.
But David Winch and the civil liberties advocates, they look at that exact same scenario and they draw a hard line. They say, you are assuming the money is dirty without proving it in a criminal court.
Because having enough evidence to make a case is vastly different from having enough evidence to win a case beyond a reasonable doubt in front of a jury.
Yes.
I mean, juries acquit people with enough evidence all the time. That's literally why we have trials.
Exactly. Winch's position is that if the state wants the £5 million, they need to do the hard work.
Yeah.
They need to spend the money, impanel the jury, run the trial, and actually prove the money laundering beyond a reasonable doubt.
You cannot take shortcuts when it comes to fundamental human rights, even if the shortcut is really, really efficient.
So it's a profound philosophical stalemate, really.
It is. It's the state's desperate need to defund criminal enterprises colliding head-on with a citizen's absolute right to not be punished until formally proven guilty.
And the charge lying on file is basically the battleground where these two ideas rip each other apart.
It completely exposes the raw seams in the justice system. It shows us that the law is not always about pure justice. It is often about resource management, pragmatic compromises, and just the quiet shifting of goalposts.
Yeah, that's exactly right.
So let's bring all of this together. We've journeyed through some incredibly complex legal architecture today.
We really have.
In the criminal courts of England and Wales, allowing a charge to lie on file is this fascinating, deeply paradoxical administrative tool. It relies entirely on a judge confirming the presence of evidence, combined with the deliberate, systemic absence of a verdict.
It's a mechanism born out of necessity, really. Courts are overwhelmed. When severe crimes are already resulting in lengthy sentences, the system triages its resources by putting lesser charges in a dormant state rather than spending public funds on redundant trials.
But as we've seen through the lens of the Proceeds of Crime Act 2002 and David Winch's razor-sharp critique, that dormant file doesn't just collect dust.
No, it doesn't.
By acting as a bridge to lower burdens of proof in civil courts, this shortcut creates a massive gray area. It allows a state to reach into your bank account and confiscate your assets based on a crime they explicitly chose not to prove you committed.
And for you listening, the ultimate takeaway here is to look closely at the invisible compromises that govern our lives. Massive systems like the legal system, the healthcare system, the financial sector, they all make compromises every single day in the name of efficiency and the public interest.
Yeah.
But we have to remain vigilant and constantly ask ourselves, how do those administrative shortcuts quietly erode the foundational principles we assume are protecting us?
That is the exact friction we are left with. The gap between the noble ideal of justice and the messy, budgeted reality of actually administering it.
Right.
Which leaves us with a final thought I want you to mull over today, long after this deep dive is over.
We started this conversation by talking about how we expect the law to be like a broken arm on an X-ray. A clean, jagged white line. Broken or not broken? Guilty or innocent?
But when a charge lies on file, you aren't looking at a clean break. You're just looking at a murky, undefined shadow on the film. And the terrifying part isn't the shadow itself, it's the realization that the state can still decide to amputate your livelihood, even when they actively refuse to give you an official diagnosis.